Good evening, everyone. I welcome each one of you to our 15th lecture series of Advocate on Record Aspirants Academy. Before going into the topic, it is our everyday prayer to recite the preamble of the Constitution of India. So I request each one of you to recite the preamble along with me. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Dear friends, whenever we start our meeting, we always recite the preamble, because preamble is the spirit of the Constitution. That is the goals embedded in the Constitution. Therefore, it is our always endeavor to see to that these goals are achieved by every day, by every moment. That is very, very important. That is how we can pay our tributes to the founding fathers of the Constitution, as well as our duty towards the future generation of our young men and women. Now, what is the topic for today? The topic for today is Article 136 of the Constitution of India, an introduction to special leave petition. This is a very, very important topic for the simple reason we all practice in the highest court of the land, that is the Honorable Supreme Court of India. And we generally, 80% of the cases are preferred in the Honorable Supreme Court by invoking this extraordinary appellate jurisdiction under Article 136. So how am I going to deal with this topic? I am going to approach this topic by asking 4 questions. Let us understand the questions and let us try to explore and find out the answers at the end of each question. I always want you to travel with me in the journey to find out the answers. The first question is, what is Article 136 deals with? What is Article 136? A plain meaning and understanding of SLP, special leave petition. Number 1. Number 2, we say it is extraordinary appellate jurisdiction. So what is the difference between extraordinary appellate jurisdiction and appellate jurisdiction of the Supreme Court of India? When you say somebody he is an extraordinary student, then you must distinguish how he is extraordinary and how he is outstanding from other students. Right? Number 2. Number 3, what are the key provisions in the Article 136? In this heading, I would be dealing with what is the judicial function, quasi-judicial function, what is executive, what is administrative orders, what is court, what is tribunal, what will not fall within the ambit of tribunal or the court within the meaning of Article 136. This is very important. right? Fourth question is, what is the scope of Article 136? To what extent this power can be exercised by the Honorable Supreme Court of India? So these are the four pertinent questions I have asked to myself, as well as I put forth before this august audience to think and then travel with me to find out answers to all these questions, dear friends. Because we must ask questions and we have to try to find out the answers. So now let me move on to the first heading or the first question. What is Article 136? Article 136 of the Constitution of India deals with an appeal to the Supreme Court, an extraordinary appellate jurisdiction of the Supreme Court. It starts with the term notwithstanding anything contained in chapter 4. The Supreme Court, each word is very, very important, dear friends, because already we have seen the difference between an advocate and extraordinary advocate is an advocate simply sees what is the plain meaning of each words, but extraordinary advocate, legendary advocates, they see the entire world behind a word. So therefore we are in the pursuit of excellence. So let us dissect those terms. So the Supreme Court may, it is not shall, dear friends, it is may. The Supreme Court may, in its discretion, grant leave to appeal against what? Against any judgment. Against any judgment, any degree, determination, sentence or order passed in any cause or matter. Passed by which court? Passed by any courts or any tribunal. See the wordings. It is not appeal to the Supreme Court from High Court. Passed by any courts or any tribunal within the territory of India. So it is so big. Judgment means, order means any order, be it interim order or final order, sentence. So everything they have kept it very openly. It is like a sky. If you look at the sky, it is everywhere. If you look at 136, it is compared with the sky. Because such a wide power vested with Article 136, therefore it is extraordinary appellate jurisdiction. And it has got yet another clause, 136 clause 2. There are two clauses, dear friends. Now we have covered 136 clause 1. What is 136 clause 2? Article 136 clause 2 says. Article 136 clause 2 says, whatever they have said in the Article 136 clause 1, that will not be applicable to clause 2. So clause 1 is the general provision. Clause 2 is an exception. Exception is, sorry sir? Yes, yes. Not only that, there are other differences also. Thank you so much. So in clause 2, it says that any judgment, any order, any determination or any sentence passed by a law relating to the armed forces, that will not be covered, that you cannot prefer an appeal to the Supreme Court under Article 136. And they have specifically left the term degree also. So whatever they have stated in Article 136 clause 1, that from any order you can appeal to the Supreme Court passed by any tribunal, does it include any law relating to the armed forces? The answer is no. That is what Article 136 clause 2 says. So now let me read, dear friends, what is Article 136 says. Article 136, special leave to appeal. It is seeking some permission. For example, generally, we were all students, even in school as well as in college, even now, and we will remain as a student of law. Whenever we take leave from the school, we write a letter seeking leave. We are suffering from fever, as I am suffering from fever. I seek leave from this school for 2 days or 3 days. So you are seeking permission from your teachers or from your principal. Likewise, this case is being seeking a permission from the Honorable Supreme Court, grant leave to appeal against the order. So what is that leave? Special leave to appeal by the Supreme Court. Clause 1. Notwithstanding anything in this chapter, the chapter may, in its discretion, the Supreme Court, very important, may, not shall, in its discretion. So it is not a matter of right given to the litigant. It is a matter of discretion vested with the Supreme Court. The Supreme Court may, in its discretion, grant special leave to appeal from where? From any judgment, decree, determination, sentence or order in any cause or matter passed or made by any court or tribunal in the territory of India. They are covering within the territory of India. You can appeal from any court in any cause passed by any tribunal to the Supreme Court. Clause 2 says, now coming to 136 clause 2, nothing in clause 1 shall apply. So therefore, whatever we have read in article 136 clause 1, nothing in clause 1 shall apply to where? To any judgment, determination, sentence or order passed or made by any court or tribunal constituted by or under any law relating to armed forces. So therefore, armed forces falls under the exception clause where 136 is not applicable. So now we have seen the two clauses, dear friends. So we have read the plain meaning, and it is a wide discretion vested with the Honorable Supreme Court, because any judgment passed in any cause, passed by any court or tribunal within the territory of India. Fine. Now let us ask ourselves this question. I am moving on to the next question. What is the difference between appellate jurisdiction and extraordinary appellate jurisdiction? This is the second question. If, for example, if we take Article 132, Article 133, Article 134 on one side, Article 136 is on the other side. What is the difference? Let us find out the difference. Appellate jurisdiction, extraordinary appellate jurisdiction. In all this Article 132, 133, 134, because it is 132 says, Article 132, appeal to the Supreme Court in certain matters. 133, appeal to the Supreme Court in civil matters. Article 134, appeal to the Supreme Court in criminal matters. This is on one side. Here, appeal to the Supreme Court by seeking leave. Fine. Now, what is the difference? Difference is, under the appellate jurisdiction, an appeal lies to the Supreme Court from judgment, final judgment. They have used the term final judgment, passed by High Court, not by any courts. Whereas in Article 136, it is not only the final judgment, but also any order passed by any court. They are not referring to by High Court. Under 136, if you see, it is not appeal to the Supreme Court from High Court, from any court. Whereas in the appellate jurisdiction, it is only a High Court to the Supreme Court. So therefore, dear friends, why such a wide power vested with the Honorable Supreme Court under 136? Very important. The reason is, a person, he may file a case in any courts, maybe a district court down south, maybe in Kashmir, wherever he files it. But when there is a miscarriage of justice, it is not only miscarriage of justice, it is grave miscarriage of justice. For ensuring fairness in the administration of justice, This is the answer, dear friends. To ensure the fairness in the administration of justice, even a person can appeal from the district court directly to the Supreme Court, bypassing High Court when there is a grave urgency, when there is a grave miscarriage of justice. So you have to establish that this is an exceptional case under which you have directly invoking Article 136. So meaning thereby, it is not a general practice in the Honorable Supreme Court that you will bypass High Court and you come to the Supreme Court. If you are bypassing High Court and coming to the Supreme Court, you need to establish that your case falls under an exceptional circumstances. Therefore, it requires a direct hearing from the Honorable Supreme Court. So what are those exceptional circumstances? As I said, when there is a grave miscarriage of justice, when there is an urgency, and when you need authoritative decision from the Honorable Supreme Court, and what prevented you from approaching the High Court, you have to establish all these grounds to maintain your special leave petition. Otherwise, generally, a High Court order is passed and then we come to the Supreme Court under 136, these questions are not asked. But when you leave the High Court, when you come directly to the Supreme Court by invoking 136 by saying any court, it may include district court also, it may include High Court also. When it is High Court, these questions are not put to you. When you come from district court, then these questions are put to you and you must establish that your case falls under an exceptional circumstances. Therefore, you have bypassed High Court and you have come to the Supreme Court. Right? So, in the extraordinary appellate jurisdiction, appeal lie to Supreme Court from even an order, be it interim order or final order, passed by any court or tribunal. Whereas in the other appellate jurisdictions, it is only the final judgment or final order, and then it appeal always lie before the Supreme Court passed against the judgment passed by the High Court. So these are the two major differences under which you can see that this is extraordinary appellate jurisdiction and this is appellate jurisdiction. Clear, dear friends? Now moving on to the next question, very, very important question. If we say passed by any court or tribunal in the territory of India, what type of court it is? What is the tribunal falls within the term tribunal? It may appear to be a tribunal, but it is not so. If it is an order, means which order? It's a judicial order? Is it a quasi-judicial order? Administrative order? Executive order? How are you going to establish for invoking Article 136? So, one of the most important judgment, dear friends, before going to the judgment, it is a constitution bench judgment. I will just give you the crux or brief facts of the case and then I will move on to the judgment, taking you to the relevant portions of the judgment. This is a judgment related to a labor dispute, a dispute between the employer and the employees union. They wanted to resolve the dispute by referring to arbitration. So both the parties voluntarily agrees to resolve their dispute by way of an arbitration under section 10 capital A clause 2 of Industrial Disputes Act 1947. Now, once the matter is referred to the arbitration, both the parties were heard, arbitration award was passed in favor of the employer. Now, who is aggrieved? Employees unions are aggrieved. They came directly to the Supreme Court under Article 136. Now, the employer is raising a preliminary objection. How is this SLP is maintainable? It is not maintainable. That is the contention of the respondents. But the appellant says it is maintainable because Article 136 says from any order, any determination. So therefore award should also be considered as an order or determination. Fine. Passed by any court or tribunal. So this is also a tribunal established under in the way of arbitrator under Industrial Disputes Act. So we are fulfilling all these two conditions. Therefore, SLP is maintainable. But the honorable judges, what they have said in this judgment, while arriving at the conclusion, what are the discussions went through in their mind? I am not going to tell you the verdict now, final verdict, whether it was maintainable or not maintainable. Now to find out this answer, what was discussed, what was argued before the court, that we are going to see, dear friends. Please take down this judgment. They have beautifully discussed what is judicial order, what is quasi-judicial order, what is administrative order, what is executive order, what is court, what is tribunal, what will not fall within the tribunal or the court. Beautiful judgment. It is the Engineering Mazdoor Sabha, Engineering Mazdoor Sabha, representing workmen employed under the Hind Cycles Limited, Hind Cycles Limited and another. I repeat, dear friends, the Engineering Mazdoor Sabha, representing workmen employed under the Hind Cycles Limited and another, versus the Hind Cycles Limited, Bombay. So from this title, the employees Mazdoor Sabha is the petitioner, Hind Cycles Limited is the employer. So it is 1963. It is reported in 1963, Supplementary 1 SCR, Supplementary Volume 1 SCR, Supreme Court Reports, page number 625. I repeat, 1963, Supplementary SCR, that is Supreme Court Reports, page number 625. This was not an ordinary bench, dear friends, not a single bench or a division bench. It is a constitution bench comprising of honorable 5 judges. I will please note down the judges' names also. Honorable Justice B.P. Sinha, Chief Justice. Honorable Justice P.B. Gajendra Katkar. Honorable Justice K.N. Vanchu, Honorable Justice K.C. Das Gupta, and Honorable Justice J.C. Shaw. So now let me give the brief background, whatever I have stated. Let me read it quickly. The dispute between the respondent company, here the respondent company is the employer. The dispute between the respondent company and its workmen was voluntarily referred to arbitration by their agreement dated December 3rd, 1959. So there was an agreement by which they wanted to resolve the matter amicably. That is under section 10 capital A of the Industrial Disputes Act 1947. Section 10A clause 2 prescribed the form of agreement which required that the parties should state that they had agreed to refer the subsisting industrial dispute to the arbitration of the persons to be named in the form. So they are agreeing to refer the matter to the arbitration under this provision. Section 18 clause 2 provided that, 18 clause 2 of the Industrial Disputes Act, 18 clause 2 provided that the arbitration award shall be binding on parties to the agreement. So it has a binding effect. The arbitrator named by the parties entered upon the reference on December 14, 1959. Now both the parties agreed to refer the matter to the arbitration, and the outcome of the arbitration would bind on them, would bind on both the parties. Now the arbitrator has also entered appearance. Now both the parties are there, arbitrator is also there to adjudicate upon the matter. The appellants The arbitrator named by the parties entered upon the reference on December 14, 1959 and pronounced his award on April 8, 1960. So, in the month of December 1959, he entered appearance. In the month of April 1960, he pronounced an award. The appellants seeking to challenge the validity of the award applied for and obtained special leave to appeal to the Supreme Court against the decision of the arbitrator. Now, award did not favor the workmen, so they preferred appeal special leave petition under Article 136 directly. The respondent pleaded, that is, the employer pleaded, that the appeal was not competent because the arbitrator was not a tribunal under Article 136 of the Constitution of India. So, the arbitrator exercising under Industrial Disputes Act will not fall within the meaning of tribunal what was prescribed under Article 136. That was the objection taken by the employer questioning the maintainability of the special leave petition filed by the workman. What did the Honorable Supreme Court said? That the decision of an arbitrator held that the decision of an arbitrator to whom industrial disputes are voluntarily referred under Section 10A of the Industrial Disputes Act 1947 is a quasi-judicial in character. Now they are testing the correctness of how he exercised the power, is a quasi-judicial in character and amounts to determination or order under Article 136 Clause 1 of the Constitution of India. They are saying there are two conditions to fulfill. One is whether will it fall under any judgment, order, degree, determination or sentence. They say the award passed by the tribunal, award passed by the arbitrator will be falling under determination or order under Article 136. So, there is no dispute. One condition is fulfilled. But what is the next condition? Was it passed by a tribunal or the court? But the arbitrator is not a tribunal. The arbitrator is not a tribunal within the meaning of that article. Why? Because the state has not invested him with its inherent judicial power. The state has not invested with him the judicial power and the power of adjudication which he exercises is derived by him from the agreement of the parties. The source of power excuse me it's all because of pollution, I guess. The power of adjudication which he exercises is derived by him from the agreement of the parties. So, it is not the state that he is getting the power, it is from the agreement, therefore, he will not fall within the meaning of tribunal. Consequently, an appeal against the decision of an arbitrator under Section 10 capital A of the Act does not lie under Article 136 of the Constitution. So, they have asked two questions, dear friends. Whether the order passed by the arbitrator, will it fall within any order or determination? The answer is yes. It is a quasi-judicial function and whatever the award is passed will fall under the definition of order or determination. It is agreed. But passed by any court or any tribunal within the territory of India, they have questioned. It is not a tribunal. Reason is the arbitrator has not derived his power from the state but from the agreement. So, therefore, he will not fall within the meaning of tribunal under Article 136. So, this is the question and this is the answer. But to reach this decision, the debate, the arguments and the discussions, findings of the Honorable Supreme Court is fantastic. They are saying we are not questioning the correctness or the character of the award, but we are questioning the character and correctness of the arbitrator. Very beautiful. They have very beautifully made a distinction between the award and the arbitrator. So I want you to, let me take you to relevant portions, dear friends. And interestingly, in this case, C.K. Daftari, we are in C.K. Daftari lawyers block. C.K. Daftari, Solicitor General of India, he has appeared in this case. Now, how the judgment, from this reading of this judgment, dear friends, we can understand many aspects. Firstly, law is common. Article 136 remains same. But how do you apply that Article 136 to each case? It is different. How do you apply facts and the law? And how do they arrive at this decision? So the passage, their journey towards the conclusion is very beautiful. Intellectual journey. It will show their wisdom and high intellectual power from reading this judgment. So in this honorable court has reproduced what is Article 136. Now they are discussing what is Article 136. It is clear. Yes. There is no paragraph here. This is at page 628. Without paragraphs, they have given the judgment. Page 628. It is clear that Article 136 clause 1 confers very wide power on this court, and as such its provisions have to be liberally construed. They start with the term, it is a wide power, therefore we need to give a liberal approach, liberal interpretation to these provisions. The constitution makers thought it necessary to clothe this court with very wide powers to deal with all orders and adjudications made by courts and tribunals in the territory of India in order to ensure, we can ask ourselves this question, why is such a wide power given to the Honorable Supreme Court? The answer is false here. To ensure fair administration of justice in this country. This is the answer. We ask ourselves this question, why Article 136 provides wide power? The answer is to ensure fair administration of justice in this territory, in this country. It is significant. Now they have said how to interpret Article 136 and they have given the reason for wide powers. Now they are going to interpret what is appellate jurisdiction, what is extraordinary appellate jurisdiction. It is significant that whereas Article 133 clause 1, 134 clause 1 provide for appeals to this court against judgments, decrees or final order. It is not any order, dear friends, it is final order passed by the high courts. It is not any courts, it is passed by the high courts. No such limitation is prescribed by Article 136 clause 1. Where is the limitation? For any courts, any orders, you come to the Supreme Court. So there is no such limitation. All courts and all tribunals in the territory of India, except those in clause 2, are subject to the appellate jurisdiction of this court under Article 136 clause 1. So all except those in clause 2 are subject to the appellate jurisdiction of this court under Article 136 clause 1. It is also clear that whereas the appellate jurisdiction of this court, dear friends, this is very important, even in advocate on record examination, they may ask, what is the difference between the appellate jurisdiction and extraordinary appellate jurisdiction? Please narrate few points. So this is very, very important. And moreover, every time when we are practicing in Supreme Court, we generally invoke 136. So this is, even for practice, even for the examination point of view, it is very important. Even otherwise, as a student of law, everyone must understand that what are the differences. It is also clear that whereas the appellate jurisdiction of this court under Articles 133 clause 1 and 134 clause 1 can be invoked only against final orders. Appeal to Supreme Court in civil cases under Article 133 clause 1, appeal to the Supreme Court in criminal matters under Article 134 clause 1, it is appeal to Supreme Court against the judgment passed by the High Court, not by any courts. Only against final orders, I repeat, it is also clear that whereas the appellate jurisdiction of this court under Article 133 Clause 1 and 134 Clause 1 can be invoked only against final orders, no such limitations is imposed by Article 136 Clause 1. In other words, the appellate jurisdiction of this court under this later provisions can be exercised even against an interlocutory order or decision. Even against an interlocutory order passed by any courts, you can come to the Supreme Court. Causes or matters covered by Article 136 Clause 1 are all causes and matters that are brought for adjudication before courts or tribunals. The sweep of this provision is thus very wide. It is true that in exercising its powers under this article, this court in its discretion, this is very, very important. It is a discretionary power vested with the Supreme Court. It is in its discretion refuses to entertain applications for special leave where it appears to the court that interference with the orders sought to be appealed against may not be necessary in the interest of justice. They are saying, though there are wide powers vested with the Supreme Court, but still in their discretion, they may not interfere in the SLP in the interest of justice. So when wide powers are given, they should use it sparingly, very cautiously, only under exceptional circumstances. But the limitations thus introduced, but where do you get all these limitations? Whether Article 136 Clause 1 said? The answer is no. Limitations is self-imposed limitations, self-imposed restrictions that Supreme Court over a period of time in their judgments they have said, though our powers are wide, but we will interfere only under exceptional circumstances. So, but the limitations thus introduced in practice are the limitations imposed by the court itself in its discretion. They are not prescribed by Article 136 Clause 1. For invoking Article 136 Clause 1, two conditions must be satisfied. Dear friends, now they are coming to what are the two conditions to invoke Article 136. So they are bringing into a very brief note. If they ask what are the conditions to invoke Article 136, there are two conditions must be satisfied. What is the first condition? The proposed appeal, that is proposed special leave petition, must be from any judgment, degree, determination, sentence or order. That is to say, it must not be against a purely executive or administrative order, number one. If the determination of or order giving rise to the appeal is a judicial or quasi-judicial determination or order, the first condition is satisfied. So the meaning thereby, Article 136 Clause 1 is splitted into two now for our purpose of understanding. You say any judgment, any order, it refers to quasi-judicial or judicial orders. It will not refer to executive or administrative orders. This is number one. So when you are invoking Article 136, you must establish that you are appealing against an order which is judicial order or which has a quasi-judicial order. That you must establish. That is the first condition. Coming to the next condition, what is the next condition? The second condition imposed by this article is that the said determination or order must have been made or passed by any court or tribunal in the territory of India. These conditions therefore require the act complained against must have the character of a judicial or quasi-judicial act, and the authority whose act is complained against must be a court or a tribunal. Unless both these conditions are satisfied, 136 Clause 1 cannot be invoked.
Second is not clear.
Yes, I will tell you. The second condition is, first condition is you can prefer specially petition against any order, judgment. Fine. Passed by whom? The second condition is passed by any court or tribunal within the territory of India. In this case, they are questioning the second condition is not fulfilled. Reason is this is not passed by a tribunal or a court, because arbitrator functioning under Industrial Disputes Act will not fall within the definition of tribunal. Therefore, 136, that is specially petition, is not maintainable. That is the contention of the respondents. Hope it is clear, dear friends. I will put it in very simple. First condition is you must establish that this is a judgment. That is a judgment, not administrative or executive, but quasi judicial or judicial orders. Number one, such judicial orders passed by court or the tribunal within the meaning of 136. These are the two conditions. Now, in this case, they have discussed courts of law established by the state decide cases brought before them judicially, and the decisions thus recorded by them fall obviously under the category of judicial decisions. They have said what is administrative, what is judicial, what is quasi judicial. They are saying it depends upon facts to facts. Where is their power they are deriving? What sort of functions they are discharging? So we cannot give a straight jacket formula. These are all the judicial functions. These are all the quasi judicial functions. We cannot say so. The distinction between purely administrative or executive acts and judicial or quasi judicial acts has been considered by this court on several occasions. In the case of province of Bombay versus Kusal Das S. Advani, this is reported in 1950 SCR 621, that is a referred judgment by Honorable Justice Mahajan. He says, observe that the question whether an act is a judicial or a quasi-judicial one or a purely executive act depends on what? Depends on the terms of the particular rule and the nature, scope and effect of the particular power in exercise of which the act may be done, and would therefore depend on the facts and circumstances of the case. Courts of law established by the state decide cases brought before them judicially, and the decisions thus recorded by them fall obviously under the category of judicial decisions. For example, Family Courts Act is there, under which family courts are established. Any matrimonial issues decided by the family court becomes a judicial order. So administrative, now coming to the administrative or executive bodies, on the other hand, are often called upon to reach decisions in several matters in a purely administrative or executive manner, and these decisions fall clearly under the category of administrative or executive orders. Even judges have in certain matters to act administratively, while administrative or executive authorities may have to act quasi-judicially in dealing with some matters entrusted to their jurisdiction. Where an authority is required to act judicially by an express provision of the statute, under which acts or by necessary implication of the said statute, the decisions of such an authority generally amount to quasi-judicial decisions. Dear friends, I am taking you to the very relevant portion. Here, what they are saying is, bearing in mind this broad distinction between acts or orders which are judicial or quasi-judicial on one hand, and the administrative or executive acts on the other, there is no difficulty. Now they are coming to this discussion of what is the issue involved. There is no difficulty in holding that the decisions of the arbitrators to whom industrial disputes are voluntarily referred under section 10A of the Act are quasi-judicial decisions, and they amount to a determination or order under Article 136 Clause 1. But what is in dispute between the parties? This is very beautiful lines. What is in dispute between the parties is not the character of the decision against which the appeals have been filed, but it is the character of the authority which decided the disputes. So we are not questioning the decision, but we are questioning the authority, whether he will fall within the ambit of tribunal or not. The respondent contend that the arbitrators whose awards are challenged are not tribunals, whereas the appellant contend they are. So after a lengthy discussion, dear friends, ultimately the Honorable Supreme Court, what did they say? In the result, the preliminary objection raised by the respondents in the appeals before us must be upheld. In the result, the preliminary objections raised by the respondent, that is the employer, in the appeal before us must be upheld, and the appeals dismissed on the ground that they are incompetent under Article 136. So in this, I request each one of you, because due to paucity of time, we cannot read the entire judgment. So therefore, dear friends, whenever your time permits, please take out this judgment and read fully. Therefore, you will understand what is court, what is tribunal, and how they have arrived at this conclusion. So this constitution bench judgment has enlightened us what is court, what is tribunal, what is judicial function, quasi-judicial function, and why the arbitrator exercise the function under Industrial Disputes Act will not fall within the tribunal, and they have compared it with the Arbitration and Conciliation Act also, how they are considered as tribunal, whereas under Industrial Disputes Act, why they have not considered. Ultimately, our legendary figure, Solicitor General C.K. Daftariji, has won this case. So this is with respect to the third question, dear friends. Now moving on to the fourth question. What is the scope of Article 136 and Article 142? Because Article 142, the Supreme Court may pass any orders to do complete justice. According to me, we will not find any parallel power vested with any courts in India except Supreme Court. To put it otherwise, the Supreme Court remains supreme only because of Article 142, because they can pass any judgments to do complete justice. We have seen economic justice, political justice, social justice, but what is complete justice? It is left to the wisdom of the honorable judges with respect to the peculiar facts and circumstances molding the relief to the litigants. That is Article 142. What is 136? It is the extraordinary appellate jurisdiction. You can appeal to the Supreme Court against any order passed by any courts or tribunals. So this is also very wide. So how do you distinguish between Article 142 and Article 136? Very, very important. For this, there is one beautiful judgment. Thanks to this AAA, that is AOR Aspirants Academy, it gives us a compulsive platform to read these important judgments. And I am very happy to all of you who are patiently listening to me, and therefore it is like learning from each other. There is a platform where we are sharing our little knowledge with you, and your presence makes the journey very beautiful. And it is one family. So what is the judgment is about? The judgment what I am talking about is Article 136, 142. Let me give you a brief background and then take you to the relevant judgment, relevant provisions also. There are, dear friends, there are two set of judgments, two judgments conflicting decisions. In one decision, one set of decisions, they say when there is excess amount paid to the government servant, whether the state can recover that excess amount which he is not entitled to, but he has not played any fraud or misrepresentation to get that excess amount, but it is by mistake of the government which they have paid him excess. Now the question is whether the state government can recover the excessive amount. Dear friends, please kindly pay attention, very, very important. Whether the state government can recover the excessive amount paid to his employees when there is no fraud or misrepresentation on his part. Purely a bona fide mistake. One set of decisions in the Honorable Supreme Court says, after all, government servants, and they are paid not because of their fraud or misrepresentation. It was bona fide mistake. Therefore, you need not recover the excessive amount paid to the employee. This is one set of decisions. What is the another set of decisions? Conflicting decision. They say, how is it possible to pay the public money in excess to the employee? It would amount to unjust enrichment. He is not lawfully entitled to. Therefore, the government can recover the excessive amount paid to the employee. So you have two different set of decisions, one with sympathy, one with law. So now when it comes to the next judges, they were enlightened, the judges were enlightened with these two conflicting decisions. Now what is the effect of when there is two conflicting decisions? Passed by division bench, division bench. Now yet another division bench requested the Honorable Chief Justice of India to constitute three judges bench to resolve this conflict. Now the matter goes before the Chief Justice and bench was constituted. Very beautifully they have distinguished under in one set of decisions where they have said it need not be recovered. According to the three judges bench, they have said, though they have exercised under Article 136, because of the peculiar circumstances, they have invoked Article 142 by holding that excessive amount will not be recovered. So it is Article 142. Therefore, you do not have any binding precedents. Therefore, it cannot be disturbed. It need not be disturbed. What about yet another judgment? They say, the five judges say, they have exercised under Article 136 and they have set the law correctly. So therefore, according to three judges bench, they say, we do not find any conflicting decisions because one set of judgments holding to recover, not to recover, it is an exercise under Article 142 of the Constitution. Therefore, it will not have any binding effect. As far as 136 is concerned, where the set of judgments order to recover, it is the correct law. Therefore, it will have a binding effect under Article 141 of the Constitution of India. So therefore, according to the three judges bench, we do not find any conflicting decisions between these two judgments. One has exercised 142, it applicable only to that particular facts and circumstances of that case. But yet another case is Article 136, where they have ordered to recover, that will have a binding effect under Article 141. So therefore, do not get confused with 136 and 142. Therefore, we do not find any conflicting decisions at all. Therefore, this reference need not be answered. Matter is sent back. So let me read, dear friends, the beautiful paragraphs, and which is judgment. Hope it is clear to everyone. So meaning thereby, when an order, when a judgment is pronounced under Article 142 of the Constitution of India, it is passed only for molding the relief to do complete justice, considering the peculiarity of the facts and circumstances of the cases. It will not operate as binding precedents. Yes, I will let it. But whereas under Article 136, they have set the law, they have propounded the law for the entire country, therefore it will act as a precedent. But to my mind, there was one question, dear friends, I will just share it with you also. When Article 142, when they exercise such power, and if we say it does not have a binding effect, but in Vishaka versus state of Rajasthan, they have invoked Article 142 and they have specifically said, until the parliament enacts the law, this will remain. as a law of the land. But in case if they want to express it, they can do so. That is my humble answer to my question. Under Article 142, they frame guidelines and they make specifically this will hold the law until the parliament comes out with the effective legislation. They specifically say, otherwise, so we can consider that generally under 142 it does not have any binding effect unless and until they expressly they say that it is binding effect. That is my humble opinion on this. Let me go to the judgment. Which judgment I am referring to? AOR 2015, the judgment, where a full judge bench. Yeah, I will just tell you the citation and then cast it. AOR 2015, Supreme Court, page number 1267. Page number 1267. It is comprising of Honorable 3 judges, Honorable Justice H.L. Dattu, Honorable Justice R.K. Agarwal, and Honorable Justice Arun Mishra. Now, Article 136. Why I am referring this? To understand the wide power of the Supreme Court under 136 also, as well as how it is distinguished from 142 also. Article 136 of the Constitution of India confers a wide discretionary power on the Supreme Court to interfere in suitable cases. Article 136 is a special jurisdiction and can be best described as a residuary power, extraordinary in its amplitude. Its limits when it chases injustice is the sky itself. Because according to the litigant, he says injustice has caused to him. So when he comes to the Supreme Court, when the Supreme Court is correcting or chasing the injustice to correct or to uphold justice, sky is the limit. So it is wide power. Article 136 of the Constitution of India was legislatively intended to be exercised by the highest court of the land with scrupulous adherence to the settled judicial principle well established by precedents in our jurisprudence. Article 136 of the Constitution is a corrective jurisdiction that vests a discretion in the Supreme Court to settle the law clear. Dear friends, when they are exercising the power under 136, that means Article 136 of the Constitution is a corrective jurisdiction that vests a discretion in the Supreme Court to settle the law clear. That means they are pronouncing the authoritative decision for the remaining courts in India to follow. So Article 141 is included there. Article 136 makes the law operational to make it a binding precedent for the future instead of keeping it vague. In short, it declares the law as under Article 141 of the Constitution. Therefore, when power is exercised under Article 136, it declares the law, number one, and it has a binding effect under Article 141 of the Constitution. Article 142, now they are coming to Article 142, dear friends. Article 142 of the Constitution is supplementary in nature and cannot supplant the substantive provisions, though they are not limited by the substantive provisions in the statute. It is a power that gives preference to equity over law. It is a justice-oriented approach as against the strict rigors of the law. So it says justice-oriented. The directions issued by the court can normally be categorized into one in the nature of molding of relief. They are talking about Article 142. 142 is justice oriented, molding the relief, and the other as the declaration of law, and the other means Article 136 is the declaration of law. The directions issued under 142 do not constitute a binding precedent, unlike Article 141 of the Constitution of India. They are directions issued to do proper justice and exercise of such power cannot be considered as law laid down by the Supreme Court under Article 141. The court have compartmentalized and differentiated the relief in the operative portion of the judgment by exercise of the powers under Article 142 of the Constitution as against the law declared. The directions of the court under Article 142 of the Constitution, while molding the relief that relax the application of law or exempt the case in hand from the rigor of law in view of the peculiar facts and circumstances, do not comprise the ratio decidendi and therefore lose its basic premise of making it a binding precedent. So ultimately, our honorable judges in paragraph 13, they have said, in that view of the above, we are of the considered opinion that reference was unnecessary. Therefore, without answering the reference, we send back the matters to the division bench for its appropriate disposal, ordered accordingly. I will give you the name of the case also. It is State of Punjab and others. State of Punjab and others versus Rafiq Masi. I spell the name R-A-F-I-Q. Rafiq M-A-S-I-H. M-A-S-I-H within bracket whitewasher. Whitewasher within bracket they have given whitewasher. Yes, State of Punjab and others versus Rafiq Masi. So dear friends, let me sum up quickly. So we have discussed about Article 136. In the first question is, what is Article 136 that we have seen? Number 2, what is the difference between appellate jurisdiction and extraordinary appellate jurisdiction of the Supreme Court? Number 3, what are the conditions to be fulfilled to invoke Article 136? 2 conditions. One is, if it is we are challenging any order or any determination, must be a judicial order or a quasi-judicial order. It cannot be administrative order or executive order. Second condition is, it must be passed by any courts or tribunal. Whether tribunal or courts falls within the meaning of Article 136, that is to be tested, and we need to fulfill those conditions. Number 4, what is the difference between extraordinary appellate jurisdiction of Supreme Court under Article 136 and to do complete justice, a plenary power vested with the Supreme Court under Article 142. So we have beautifully seen the distinction between 136 and 142. So this is what a basic introduction to special leave petitions. But we have a long way to go with respect to Article 136 itself. It will help us in many ways. Firstly, it will help us as a student of law, it will help us to understand what is Article 136. Number 2, 80% of the cases are filed in Supreme Court under Article 136. Once we master in Article 136, we can frame grounds also on what basis you can attack the High Court order. Even you can attack the High Court order by saying it is a non-speaking order, an order passed without reasons. And even you can bring out, even in the concurrent findings, generally the Honorable Supreme Court poses a question to us. When there is a concurrent finding, why are you before us? But there are judgments which says, even in a concurrent finding, you can appeal to the Supreme Court by special leave when there is a perversity, when there are many ways. Even interlocutory order can be challenged under SLP. So I think we will have many sessions on Article 136. It will help us in all the aspects, dear friends. I thank wholeheartedly each one of you for your patience hearing. Thank you so much for your support and encouragement. Thank you.